Thank you for joining me this evening. Again, my name is Jordan Walker. I'm with Seaver Walker Paget Law Firm. Tonight, we're going to be talking about the Southern Illinois Pipeline project. And with that being said, let me go ahead and share my screen, and we will get started. Thank you again for joining us this evening. This is the agenda of what we're going to talk about today. We will have questions or time at the end for questions if you have any. So hopefully we address those questions as we get into this presentation. What we are going to talk about today, obviously we're going to talk about the Southern Illinois Connector Project. We're going to talk about eminent domain. How does that factor into it? What is it? Does the pipeline have the ability to exercise it? We're going to talk about negotiations with the pipeline. How's that going to go? What to expect? What to look out for? And then, of course, like I said, we'll take questions, and if you guys have any questions about your case specifically, we can also talk about that on a one-on-one phone call if you'd like. So, real quick, just a little bit more about our firm, so you understand where we're coming from and where this presentation is coming from, and our experience in this field. Seaver Walker Paget is an eminent domain only law firm. We are an eminent domain only, landowner only law firm. We only represent landowners. We only do eminent domain. So if you go to our website, landownerattorneys.com, you'll see nothing but eminent domain. You're not going to see anything about personal injury or bankruptcy or any other type of law. This is the only area of law that we practice. And as a consequence, because this is the only area of law that we practice and indeed only represent landowners, we've learned quite a bit. And we don't just do this in Illinois. I myself am our Illinois attorney. I'm licensed in 5 states as we sit here. So I've done work in those states and in other states with local counsel agreements. So we've done this across the country, not just in Illinois, not just in Indiana, not just in the Midwest. We've done it across the country. We've dealt with pipelines of all sizes, of all types, energy companies of all types. We've dealt with the energy companies that are building this project specifically. And so as a consequence, like I said, we've learned a lot. We see how the pipelines operate. We see how their right-of-way agents operate. We know their tricks and what they like to do. And because we do this so much, we've learned a lot. And today, my job and what I hope to accomplish is to impart on you some of that knowledge that we've accrued so that when they come to you and present an offer to you, if they come to you and present an offer to you, you'll know what to do, how to handle it, what to look for, and how to protect your property. Ultimately, at the end of the day, that's what we're going to be talking about really is how to protect your property, how to make the best out of a situation that you probably don't want to deal with. So that's our goal today, and I think we're going to accomplish it. And we'll get into eminent domain real quick. I do want to provide a little background about why you got this letter. Actually, we're going to talk about the project first, and then we'll get into eminent domain. But I do want to talk about why you got the letter. So the Southern Illinois Connector Project currently is before the ICC. The ICC is the Illinois Commerce Commission. In Illinois, for pipelines and power lines to be built, they require permission from the Illinois Commerce Commission, which is a utility regulatory body in Illinois. So currently, the Southern Illinois Connector Pipeline is before the ICC. There's a docket number. It's actually on this slide right here. And so they are before the ICC right now trying to get that authority to build the line. Along with that authority to build the line, they are seeking eminent domain authority. So, which we expect, I should say, we expect the project to be approved and we expect them to get eminent domain authority along with it. So that's where the project is right now. It's before the ICC. They just filed their petition or their application earlier this year. You might be a landowner who's interested in getting involved in that process. That's not something we generally do. getting involved in the ICC process, mainly because from our vantage point, from what we've seen on this before the ICC and before any governing body on these projects, is that a lot of times it is a rubber stamp situation for the governing body, wherein the companies show up, they say, "Hey, we want to build this project," and there is a process certainly that the governing body goes through. They take input from landowners and from interested parties and people who want to say their piece. Ultimately, though, from what we've seen, is that if the pipeline wants to build this project, if the power line wants to build this project, whatever utility we're dealing with, generally speaking, they are successful in getting the necessary permits to build the project. So I'm not saying it's a foregone conclusion, and if this is something that you're interested in getting involved with at the ICC level, you of course have that ability. If you see this docket number right here, this is the ICC docket number. If you're interested in getting involved with the ICC process, just Google, you could probably just Google Southern Illinois Connector Pipeline Project and ICC, and it'll take you to the docket, and then you can intervene if you so choose. But back to why you got the letter from us. The reason you got the letter from us, we of course do not work for the pipeline. They are not going to share any information with us. So we have to monitor these projects, the best we can. And as part of the ICC process, they identified affected landowners by the project. So we were able to get that information from the ICC and then send you a letter. So our information is based off of the ICC information, which of course is all public record. So just to give you, I guess, some background of why you received a letter specifically from us about this. So a little bit more about the project specifically. It is a 57-mile pipeline. It starts at Wood River and it ends in Patoka. Patoka is or the Patoka hub. These are two very common start and end points for energy companies. They are big distribution spots for Enbridge and Energy Transfer and other utility companies in Illinois. So not uncommon for this type of pipeline to be built in this area. And so it's a 57-mile pipeline. It's 24-inch diameter. 24 inches, I would say, is a mid-sized pipeline. They go up to, up to 42 inches and larger, I believe. 42 inches is usually about as big as it gets, and then they can get down to 6 or 12 inches. So this is about right in the middle as far as pipelines are concerned. It is transmitting crude oil, which, because it's crude oil, it allows the ICC to be the main governing body, as opposed to the Federal Energy Regulatory Commission, who would have administrative authority if this were a natural gas pipeline, for example. It is not, though, and so we're dealing with the ICC and Illinois law. So that's, I think a 10,000-foot view of the project, what's going on, why we got, or how we got your information, why you got it from us. If this is the first you're hearing about it, that happens a lot, that we are unfortunately the bearers of bad news, and that we mail out to folks that haven't even heard from the pipeline yet. The good news is that being early is better than being late. So the fact that you're part of this webinar and getting this information now, as opposed to later on in the process, can only serve to assist you moving forward. So once we will get into the negotiations, how to handle it. I want to talk real quick about what eminent domain is. Eminent domain is the inherent power of the government, or in this case, a private entity with eminent domain authority granted by the government to take private property for public use. So essentially, eminent domain is most often seen with road projects, or more commonly seen with road projects, IDOT, Illinois Tollway, or if you're getting into Missouri, MoDOT. So roads obviously have to be built, and the government acquires land from private landowners to build those roads, whether the landowners like it or not. The same power applies to this situation. And you might ask yourself, well, that's a road, and this is a pipeline, and this is a private entity, and they're going to make money off this, so how do they have eminent domain authority? And those are all incredibly valid issues and questions, some that I myself raise as well often. Unfortunately, the reality is that the law allows these types of pipelines to exercise eminent domain. It is delegated to them by Illinois law via the certificate of public convenience and necessity and the approval of eminent domain from the ICC. So, because of that, that delegation, they will have the ability to condemn, which condemn is used interchangeably with eminent domain. Condemnation and eminent domain are the same thing, at least in this situation. Some people think of condemning as boarded up houses. That's actually a different type of condemnation. So in any event, uh, what we're talking the takeaway from all of this is that we expect the pipeline to have the ability to exercise eminent domain, and you should expect it as well. And so that kind of tilts the negotiations. Eminent domain, it's not a scenario where you can just say no forever and they'll go away like your neighbor. If your neighbor wants to buy your house, you don't want to sell, you can just say no for the rest of your life and you won't sell it. In this scenario, you can't just say no forever. Eventually, they will use the courts to get your property. So it changes the negotiations between you and the pipeline. They like to carry this ability as a cudgel against landowners to try to intimidate or get them into accepting offers that they shouldn't accept. So that is eminent domain. I should say, on the other side of that coin, the flip side of that coin, with that great power, that ability to take land comes responsibility, and the responsibility and what you're entitled to, in fact, is just compensation. And what just compensation means is that you're entitled to whatever the market indicates, and beyond that, whatever a jury says you're entitled to. So if your case reaches eminent domain, if it continues down that path, I'm not saying it will. In fact, it likely won't. But if it does, and if it gets down the entire process, at the end of that process, you have the option of presenting your arguments on compensation to a jury of your peers. So ultimately, you have that option that is guaranteed to you. You have that as a matter of right. So again, not saying your case will reach that point, but you have that ability to take your case to court if you so choose. So just compensation is the responsibility that they are beholden to. They have to give you just compensation for your property. And as you might imagine, a lot of times they do not make offers to landowners representative of just compensation, and that's the reality that we have seen, and it also kind of necessitates our existence. There's a reason our firm exists, and it's not because pipelines, power lines, governments come in and offer top dollar to landowners. Oftentimes they lowball landowners. They provide terrible easements. They don't negotiate in good faith. All of these things happen because they have this eminent domain that they can wield over landowners. So it's incumbent upon the landowner to get proper compensation or to raise their voice or to fight against them to get the pipeline to where they need to be and how they need to compensate you. And we'll talk about that more, of course. So we talked about eminent domain. We talked about condemnation. The way it works in Illinois, Enbridge cannot file a suit tomorrow. They have no ability to. They are not delegated that authority yet. They can only file their condemnation after they've first of all, gotten their ICC certificate, but second of all, issued you an offer of compensation for your property. Some of you already have an offer. Some of you don't. Um, no reason to be concerned if you don't have an offer. At the end of the day, if the pipeline wants your land, you will know. It is not a light touch. We'll get into right-of-way agents here in a bit, but they are very present. They will issue the offer and they will stick around and call you and stop by and do anything they can in their bag of tricks to get you to sign that agreement. So if your property is affected, you will know. You will know because they will issue you an offer and they will hound you unless you instruct them otherwise to get a deal done. So, some people contact me and they say, "Well, it's been months and I haven't received an offer." And the reality is, the pipeline will come to you at their leisure. You say, "Well, my neighbor's got an offer, but I don't." We don't know what strategy or schedule this pipeline is on. We can't know that. That's internal to their companies. So we don't know when they're going to come out to you. All we can do is react to what to do when they do issue the offer. Ultimately, if they never come to you, they can't take your land. It's as simple as that. They have to come to you. These are statutory requirements, um, and uh, and yeah, you will absolutely know. A lot of people get concerned. I tell people just you got to trust me. They're very present. Um, where we are right now, we are at the offer stage. They are starting to issue offers. I would expect those offers to continue through the summer. We are in phase one of this process, and as you see by this little subnote, this is the moment of what I call maximum leverage. What we call maximum leverage. This pre-condemnation um, stage we are in. This is where the landowner has the most leverage. This is where the landowner can generally get the best deal if they handle it properly. This is where they can get their easement properly crafted and drafted. So we're in, once you get that offer, that is the time to take it serious. I mean, you're already taking it serious, and frankly, you might want to take it serious even before the offer comes in. But when the offer is issued, that's the time to act. And we'll get into what to do and what not to do. But if you have an offer on the table, the time to decide how you're handling that offer is now. Until that time, you can decide how you want to handle it, or maybe attend a webinar or ask me questions, and just prepare for when that time comes and what you need to do. So they are going to issue you offer if you're affected there. And what is going to be part of that offer? Well, you're going to get the compensation offer, which will come, in a letter or a calculation sheet or some sort of summary statement. But you're also going to get the document that they want from you, and that's the easement. And an easement, if you don't know, is effectively, or not effectively, it's a deed, it is a type of conveyance, property conveyance. But instead of a full deeded transfer where you convey full title, which is the traditional sale of property, you sell your property to somebody else, you sell title, full title, fee simple title to them. We're not selling title. You're not selling title to the pipeline. You're selling an easement to the pipeline. They are buying an easement from you or condemning an easement. And an easement is the right to use the property for a specific use. And the one question of all sorts of variations I get is, what are they allowed to do? What's the pipeline allowed to do? What are they not allowed to do? And the answer to that question invariably is it all depends on what that easement says and what that document that you'll have to sign eventually says. It doesn't matter what they tell you in your living room in June 2026. What matters is what that document says, and that is the document that will be recorded. That is the document that will stick with the property forever. That's important to note. Easements are forever. They do not go away unless there's an operation that allows them to go away. For example, if there's abandonment language in the easement that requires them to clear the title in the event the pipeline is abandoned. Short of something like that happening, this easement's going to be there forever. And so it's going to affect your kids' kids, whoever inherits the property, whoever you sell the property to. The easement will be there when they pull the title on the property. It'll show this easement. And that's why it's imperative that you make sure this document is crafted very well. What I see, and some landowners might even be familiar with this, is that ancient easements become modern easements. And ancient easements, a lot of times, are poorly drafted. I have seen too many existing easement agreements that landowners have, and I'm sure Enbridge or Energy Transfer has existing easements on some of your properties as we sit here. I've seen too many of these old documents that were signed decades ago that are just incredibly poorly drafted. They were, I'm sure very little negotiation. Attorneys were not involved, at least for the landowner. Money was exchanged. They said, hey, we're going to build a pipeline. That was that. And the reality is a lot of times these old easements are and modern easements for that matter, are poorly drafted. In fact, I would bet, and I have not seen the easement that Enbridge or the Energy Transfer Partners has presented to landowners yet, but I would bet that it is incredibly broad. I would bet that it gives them way more than what they're telling you at your dinner table when they're trying to get you to sign it. I would bet it gives them the right to build more lines. I would bet it includes a lot of the clauses that I mentioned right here on this slide. unfettered access, a blanket easement across the property, the right to enter your property whenever they want. No restoration clause, that there's no clause in there that says they need to fix what they break. Clauses that shift liability to you. This is something that happens quite a bit. Then, if there's an accident on the easement that is part of the pipeline, you might be liable or partially liable for what's going on that you had nothing to do with. The right to sell their easement rights to other companies, assign their rights to third party entities. We see it a lot where utility companies acquire the right to build fiber optic cable, and it seems kind of odd. Why do they care about that? And it's because it's not for them. It's for them down the road to sell that specific right, the right to lay fiber optic, to AT&T or Verizon, so that they then pay the pipeline to build that fiber optic on your line or on your property in the easement, and you not get anything. This is what they will do. We've seen it too many times. No clauses that stipulate what happens in the event of future damages or relieves them of any liability for future damages. The big one, another big one I see is the right to add more lines. This is very common for them to say, hey, we're only building one oil pipeline. And then if you read the easement, it says the right to build one pipeline or add to the number of or enlarge in, or that, and it in the easement description describes the entirety of the property. So you thought you were selling the right to build one pipeline. Turns out you were selling the right to build as many pipelines as they want. And with that right, their ability to do it without coming back in and giving you more money when they lay that second or third pipeline. So, I have not seen, again, have not seen the easement yet. This is our first marketing venture on this, but I would suspect that there's a lot that needs to be changed, added, or fixed about the easement that's been presented to you. So, and I'm happy to look at those easements. If you have an offer and you want me to look at it, and we'll talk about it more, I'm happy to review any offer you have for free. We don't charge for offer reviews. We never have. We never will. If you have an offer and you want me to look at it, I will look at it for free and I'll give you my thoughts and you can decide what you want to do. So we talked about easement language, and for some people that's the most important, but for other people they don't care and they're just concerned about the compensation. Well, needless to say, the pipelines generally do not come in and offer a decent amount of money, and usually like to lowball in that regard as well. You are entitled to, again, just compensation, and that's not what the pipeline says you're entitled to. It's what the market says you're entitled to, or ultimately a jury. You're entitled to effectively, what is the difference in the value of the entirety of your property before and after the pipeline? The difference between those two numbers is what you're entitled to. What was the property worth now? What will it be worth after the pipeline goes in? And so when you might say, well, how is that? How would it be affected? What's the relevance of the rest of the property? And the relevance of the rest of the property is that some people don't want to buy pipeline or properties with pipelines on them. Some people don't care. Some people do care. And because some people do care, that tends to lessen the fair market value of the property. People don't want to deal with pipelines. They don't want to deal with spills. They don't want to deal with fires, explosions. No matter how remote the possibility might be that might occur, people don't want to deal with pipelines. And the reality is not wanting to deal with pipelines drives the value of properties down, those with pipelines versus those without. And so you're entitled to however the pipeline depreciates your property. And how it depreciates your property depends on any number of factors, how it cuts through the property, are there existing lines on the property already? Where is it going? What is the property being used for? All of these things, they factor into what you're entitled to. But at the end of the day, it's not just about what they're taking, it's about what they're leaving behind. And for some folks, they can really tear up a property, really do some damage to it, and cause a lot of issues to the value of those properties. And that's one of those things that they do not like talking about. If you start talking to a right-of-way negotiation, a right-of-way agent, and you start talking about a remainder damage, they're going to tell you it's not a thing. It's not a real thing. And remainder damage is the term that we use for the impact on the rest of the parcel. It goes by many different names: consequential damages, diminution in value. They're all the same thing. How does the pipeline affect the rest of the parcel? Right-of-way agents for the pipeline are not going to want to talk about it. They are not going to acknowledge it. They'll say it doesn't exist, and they will just push forward without it being a thing. You have to make it a thing for them that they need to recognize and they need to compensate you for. And that's something that we, of course, do for our folks. So you're obviously entitled to the before and after. You're entitled to crop and land damages. A lot of times they offer crop damages, sometimes not enough, sometimes they're okay. I haven't seen them on this one yet. But you should be fully compensated up front for these damages, because trying to get it after the fact is like pulling teeth. You want to get paid now for any potential damages. And beyond that, you want to get paid for land damages if they exist, or have a clause that requires them to remediate and fix or reimburse you. One thing that happens with these pipeline construction projects is that they construct in wet weather. And if there isn't sufficient protection in your easement or your documents that requires them to fix, all the compaction, the tearing up the ground, the ruts, the depressions, all of that, the contouring of the property. If you don't have something that requires them to do it, they're not going to do it, or they're not going to do a very good job, and they're going to leave your property looking like crap, potentially. So it's important to, of course, make sure you get strong language that protects you, and if necessary, get paid up front for things that'll definitely happen. And then finally, it's important to remember that you have leverage. Your ability to say no to them gives you leverage. Your ability to hire counsel that they respect gives you leverage. And leverage is everything. They want your land. You know it. Make them pay for it. And the best way to do that is to leverage your position to make you be somebody that the pipeline needs to deal with. A lot of folks on this line, and every line for that matter, I would say 60, 70% take the first, second offer. It's unfortunately something we try to fight, try to get in front of people before they do it. We wish we were as effective as the pipeline is with their right-of-way agents. Unfortunately, we can only do so much. And so a lot of people don't know the leverage that they have. So they're scared. They hear eminent domain. They say, okay, I don't want to deal with this, whatever. And they get it done. They sign a bad document. They get lowballed, and they get taken advantage of. That's not the proper attitude. Understand the power of saying no and how that leverages your position against them. Your ability to say no, your ability to go at your pace. These are all moves that leverage your position and leads to a better deal. So now I want to talk about right-of-way agents real quick, and then we'll do a little more advice, and then we'll wrap up. So right-of-way agents are the people that will be coming to you presenting the offer. I deal with right-of-way agents pretty much on a daily basis. So I've seen pretty much everything they do and what they try to do. I think that, tactics are different across each state. I think it's easy to just remember what their motivation is and who's paying them. What are they motivated by? Are they motivated to get you a good easement with a lot of money? No. They're motivated to get your property. They're motivated to sell you on the concept of you selling them your property for what they're offering based on what they're telling you. That is their job. That's how they get paid. Those are their motives. So putting aside, what they might do when they meet with you, just keep that in the back of your mind. Remember what their motivation is. It's the easiest way to explain anyone's decision making, including right-of-way agents. So in an effort to sell you on you selling them the easement, they will employ strategies that we have seen consistently across states. We've seen 125 or some percentage above 100% of fair market value, again, to make it seem like they're giving you a deal. And also to avoid having discussions of remainder damage. The more you have a discussion about the price per acre of your land in the easement, and say, okay, they think it's worth 16, I think it's worth 17, 18, we're quibbling over that. If you engage in that discussion, you are losing. You are playing into their hands. because talking about a 2 acre at best acquisition, not at best, people are obviously have larger easements, but for example, talking about a 2 acre easement at $16,000 an acre, that's 32,000. If you increase that to 19,000, you're at 38. That's a win for the pipeline. You might think you came out on top because you got them up to 19, but you probably missed out on a lot more money that was sitting out there because you didn't think about remainder damage. You didn't think about the land damage. You weren't focused on the crop damages. All the other figures that can really escalate the number. Quibbling over price per acre is exactly what they want you to do. Um, I've seen offers that are issued and then they're taken away or they're lowered and raised, and they're all again motivated to do one of two things: make it seem like they're your friend or scare you into a decision. So that's really what it comes down to. They'll be your best friend, worst enemy. They're both with the same purpose, and that is to get you to agree to something that you probably shouldn't be agreeing to. Um, Bonus payments, again, time pressure offers, trying to get you to make a decision. A quick decision is usually a bad one, especially when it comes to eminent domain and these types of acquisitions. We have some time. They want to make it seem like you don't have time. We have some time. You have the time to say no. This is your property. You don't need to agree to anything right now. Do your due diligence and go at your own time, go at your own speed, and take back the leverage from them. They want you to go at their speed. Verbal promises. This is something I see a lot. Verbal promises, as you might imagine, mean nothing for property transfers. Property transfers are governed by what the document says. So it doesn't matter what they tell you verbally. Oh, we're going to do this, we're going to do that, yada yada yada. It means literally nothing. If they come to you and they start saying that stuff, say put it in writing, write it down. The pipeline shall do this. Have them commit to what they say they'll do. Have them write it down. If they want to issue you an offer, have them write it down. They love to have these kind of nebulous offers that are not quite clear if they're official or not, and they maybe test the waters to see if it's something you're interested in. These are all things that we've seen, and it's just the type of tactics we've dealt with. We don't really deal with it because they don't try them with us, but it's what we've seen landowners have to deal with. So with that being said, this is my advice as far as what to do and what not to do when you receive an offer. What to do. Uh, this can't be stressed enough. Make sure there is a record of all the conversations you have with them. If you're going to have conversations with them. Frankly, my full advice is for you not to not talk to them at all. Have them talk to your attorney and go through your attorney. Go through your attorney. That is the foolproof way of handling the situation, is to just have them contact your attorney and let them do everything. But they are going to reach out to you first. They're very unlikely to reach out to your counsel first. So they'll reach out, and if they want to reach out, have them email everything. Have them email the offer and then say, thank you, we'll review, and they'll get back to you. And then after you get the offer and you're reviewing it, you contact an eminent domain attorney, you send the offer to them, have them look at it, have them give you your thoughts, and then decide if you want them to handle it or if you're going to handle it yourself. And so that is the foolproof way to handle it. Do your due diligence. Don't launch into negotiations. They love that. They want you to launch into a negotiation and start saying what you think the property's worth and start saying all these things about what you think you're entitled to, because they love saying that. They want you to commit to something, because as soon as you commit to something, they're going to write it down, keep it in their pad, their journal, and that little statement you made is going to stick with you the rest of your negotiations, whether it goes to eminent domain or not. And they're going to know what you said you'd take. And it's going to be very difficult to get beyond that when you've already told them what you would have taken. For example, if you're offered $20,000 and you say, well, I think I'd do 30, and they say, okay, let's do it. And then you have second thoughts, you contact me, and I look at it and say, whoa, you should be getting 100, 150 here. I can do so much, but you already told him you take 30. And that's very difficult to get past that. And the attorneys know that, and all that. And the pipeline will know it as well, and it'll just stick with you forever. So, people want to launch into negotiations, and that's how people get burned. Um, So what I say again, do communication via writing, texting, no phone calls, no in-person discussions. Just send the email, send the offer. We'll look at it. We'll get back in touch with you. The reason why I say that you should say you'll get back in touch with them is because if you don't, or you say I'll get back in touch with you in a week. If you don't say that, they're going to keep bugging you. You eventually, they do not care. They're going to keep talking to you unless you make it clear that you don't want to be bothered, or if you have counsel, they're just going to keep bugging you. But if you give yourself a week, maybe 2 weeks to do what you're supposed to, they'll respect that. They should respect that. They'll probably reach out after 2 weeks and say what's going on. But this allows you at least to give some time to breathe and not be rushed into a decision and be hounded by right-of-way agents. Um, if you can, back to what you should be doing, if you can get a group together, group is, again, it's all about leverage, and a group leverages the results for everybody. So if you can form a group that's represented by the same council, that leverage can, the leverage of the group can bleed down to everybody. Read all the documents, read the easement, save anything they provide you. These are steps if you take, you should be in good shape. What not to do, we already talked about some of these. Don't talk about value. Don't meet in person. Keep it written. Don't go out and get an appraisal before talking to your attorney. One thing that landowners want to do or think they should do, and it's logical, to think this, is that when they get an offer, they say, well, no, that's not right. I'm going to get my own appraisal and I'm going to show them what the property is actually worth. That is a mistake for several reasons. One, eminent domain appraisals are not cheap. They are expensive. This is not like getting a lender appraisal. And if it is cheap, it's probably because it's done by somebody that doesn't know what they're doing. They're expensive because there are very few eminent domain appraisers that know what they're doing. There's even fewer that know what they're doing with pipelines. And so I don't want you to go out and spend money you don't need to. And oftentimes, in fact, 99% of the time, we're able to get these cases done without spending any further money on appraisers or third-party experts or anything like that. So if you don't need to spend it, there's no reason to do it. So I generally don't recommend doing that for many reasons. It's not a good use of money, and it can backfire. It can backfire in a bad way. Um, don't take promises at face value. We already talked about that. Don't sign anything because you feel like you're under a deadline. I can tell you right now, you are not under a deadline, or at least not one that's relevant right now. So you have time. Don't ignore the offer. Those are kind of the two competing thoughts, but they are consistent. Don't be pressured, but also don't just let it sit there forever and not do anything about it. You're going to want to address it eventually. The easiest way to do that is to contact an attorney and let them handle it. But if you're not going to do that, this is not something you want to just let it lie and then all of a sudden you're in court. You might want to be in court, but you don't know that if you don't acknowledge it and look at it and do your due diligence and see what type of resolution you should be expecting. I've had far too many people contact me way too late in the process, and I just can't help them because it's not a case that we can take, given the circumstances. So, you have time, but also don't just put this on the back burner and let it sit there forever. So, how do you afford to hire an attorney if you are going to hire an attorney? So I can only speak for how our firm operates. Most people think of hiring attorneys. They think of billable hours. They think of giant retainer payments to secure representation. That is not how we work. We operate on a contingency fee, meaning, and this is the third option right here. So basically, our fee comes out at the end. You don't need to send me money to hire me. If you want to hire me, it's as simple as signing a contract, and I get started. Our fee comes out at the end. We do not get paid if we don't get you more money than what is offered. And if we do get you more than what's offered, we get a third of any amounts we recover over and above the offer from the pipeline. So the reason why we do this is people don't want to pay for attorneys. We get it. This allows you to hire an attorney without coming out of pocket. But I think more importantly, we obviously don't know each other. I'm a stranger to you people. But you can probably assume that as an attorney or just as a person, I'm interested in making money and getting, and in this relationship, every extra dollar I get for my clients is 33 cents in my pocket. So we are incentivized, we are motivated, we are aligned, we have the same goals, and we are in the same boat. And that's why we like doing it this way because, you don't need to, you don't necessarily need to have a close personal relationship with your eminent domain attorney if your eminent domain attorney has the same goal as you do, and that is to get as much money with a proper easement, for the landowner. So that's why we work that way. If you're interested in other arrangements, we can certainly talk about that. I'm almost to the end of the presentation. We'll open up for questions. Um, what to do going from here. If you have an offer, that's the time to hire counsel. Uh, if you don't have an offer yet, it's a little early. But as soon as you get that offer, go in what I say, go ahead and send it to me. I'll look at it. You don't even need to tell me it's coming. I look at offers all the time. Just send it to me. I'll look at it and I'll give you my thoughts. Talk to your neighbors. We talked about that. If you can get leverage a group, that can be very powerful for landowners. And with that being said, I'm going to open these up for questions. These are, let me get that back up so so you guys can see our contact information. So, um, yeah, so this is our contact information. This is my email. If you have questions that you don't maybe think of later, and you don't ask now, that's fine. You're not going to get a bill from me. We don't invoice for these types of things. It's as simple as just sending me, a question or your offer, and I look at it and we go from there. You can also call me if you want to have some discussion. You can also, email is probably easiest. So if you have a question, just send me an email and we can go from there. So, with that being said, I'm going to go ahead and take questions. So, if you see there's a chat button there at the bottom, go ahead and type any questions you might have into that, and I will answer them. Okay, I'm not seeing any questions, which is not a problem. That means hopefully I did a good job. Um, what I will say while I'm talking, and if anyone has a question, feel free to ask. This presentation will be available via recording. So if a family member or a neighbor wasn't able to attend, feel free to have them contact me, and we can send them the recording of the webinar. It'll also be on our website, and also you will get a recording link. And there's a question right now. Can you email the presentation? Was the question that I just got. Yes, you can. Just send me an email, and that you'd like it, and I can send it over to you. That's not a problem. Other questions? Okay. Well, no questions. Guys were easy. Well, listen, I thank you for your time. I appreciate you guys stopping by tonight. I hope you learned something. If you have questions, like I said, just shoot me an email. Happy to answer any questions you might have. Again, we don't charge, or otherwise, just go ahead and send me your offer, and we can go from there. There's a question that a copy. So the question is there a copy of the route? The route. I do have a route map. It is. I can't tell you that it's going to be great. It's the same route that was submitted to the Illinois Commerce Commission. So if you want a copy of the map of the route of the pipeline, again, you can just email me, and I can send you what I have, both in the presentation, um, and the route. And also, just there's some questions about email addresses or what have you. I think the easiest way is just to send me an email, as opposed to send me your email. So just if you have questions, you have my email. It's right there, Jordan at swp-legal.com. Send me questions, and I will request for information. I'm happy to answer them. Okay. Well, it doesn't look like there's any more questions. So thank you so much, everybody, for stopping by. I hope you have a good night and let me know if you need help.